Good afternoon, everyone, and good morning to those of you joining us on the West Coast today. Siegel Consulting and Simpson Consulting would like to welcome you to today's online presentation, ACA Update, King v. Burwell, United States Supreme Court upholds ACA subsidies in all states. Just a brief reminder, both Siegel Consulting and Simpson Consulting are members of the Siegel Group. On today's call, our presenters will address the court decision as it applies to both public sector and private sector employers. And now I will introduce our speakers. We have Ed Kaplan, Senior Vice President, National Health Practice Leader, Joanne Husted, Vice President, Deputy Practice Leader, and National Health Compliance Leader, and Catherine Bakich, Senior Vice President and National Health Compliance Practice Leader. Now I'll turn the call over to Kathy.
Thank you, Liza. Good afternoon, everybody. We're going to talk today about the Affordable Care Act decision in King versus Burwell. We're also going to talk about how it affects employer-sponsored plans and some of the issues that it's raised in terms of legislation that's being introduced, as well as new regulations that we expect to be coming. Then we're going to spend a few minutes on some of the key issues that employers have to deal with after King versus Burwell, including employer reporting, which Joanne Husted is going to talk about, and then some of the financial issues related to your plans, including the excise tax, which Ed Kaplan is going to cover. And I hope that you will take advantage of the electronic ability to ask questions. You can ask questions now or at the end of the session. So as you know, King versus Burwell was recently decided by the Supreme Court. The issues in King versus Burwell was whether the federal subsidy for premium assistance tax credits for the exchanges are available in states that have a federal exchange rather than a state exchange. The ACA, as you know, has a premium assistance tax credit that's available to taxpayers under Section 36B of the Internal Revenue Code. In order to get that tax credit, you have to meet certain financial requirements, including having an income between 100 and 400% of the federal poverty level, and you have to enroll in a plan that's offered through an exchange, either the federal exchange or a state exchange. Now, when the law was first implemented in regulations, the Treasury Department and Internal Revenue Service issued regulations that stated that the tax credits were available on both the state and federal exchanges. They did anticipate this argument being raised because there were some interest groups that were already starting to say that perhaps the ACA had a hole in it where they had left a gap that only allowed these premium assistance tax credits to be available in the state exchanges and not in the federal exchange. So that was floating around out there when the regulations were passed, were implemented, and Treasury had an extensive discussion in their regulations of why they felt that it was important to make sure that the subsidies were available in both the state and federal exchanges. Right now, about 37 states use healthcare.gov for 2015 enrollment in the exchanges. Now, there are 34 states that have relied on the federal exchanges, and then 3 more states use the federal enrollment system to enroll people. It wasn't clear whether established by the state that was at issue in this case was referring to states that had their own exchanges or were using the federal exchange. There's some ambiguity about when you can have a combination of the two, but for right now, let's just assume that 37 states that used healthcare.gov had their possibility of premium assistance tax credits being threatened by this case. So the court, when they looked at the case, first of all, they went over the intent of the Affordable Care Act. And they had a long discussion. I heard one former Representative Earl Pomeroy was talking about this, and he said it was an insurance commissioner's dream decision because they went through all of the different aspects of insurance reform and what worked and what didn't work. And that's exactly what the court did. They said that previous efforts at insurance reform had failed when states did not give a thoughtful approach to reform and use a variety of different approaches to modify the insurance markets.